First, let's start with the background. How does all this come about? The matter of Adamus Mining now having lost some concessions because of initial concerns the Minerals Commission had. What were the concerns, and why did they have to go to the minister, come back again for a committee to look at?
Good morning to you and your cherished listeners. As part of the mandate of the Minerals Commission, by law, the Minerals Commission is supposed to manage and regulate all mineral resources of the Republic of Ghana. So as part of the job, the Inspectorate Division of the Minerals Commission does inspection, some weekly, monthly, quarterly, and yearly in the mining areas where we have granted mineral rights. But let me state emphatically that when it comes to mining, it is one of the well-regulated areas in the Republic. So if you are granted a mineral right, i.e. recognizance license, prospecting license, restricted mining lease, small-scale mining lease, or mining lease itself, it comes with some conditions, some stipulations, some conventions. So you need to know all of them and abide by them. One of them is that when you look at Section 14 of the Minerals and Mining Act, because the minerals that you have been granted a mineral right on is vested in the president to hold in custody for and on behalf of the Ghanaian people, it is not for you. So when you are granted a mineral right, like a mining lease, for a period of time, you hold that mineral right for that period, and it is only you. So when you say a person, it can be an artificial person or an individual. So artificial persons are companies. When in the course of your activity, it has become possible that you want to assign to a different company, you need to seek the express consent of the minister responsible for mines, in this case, the Minister for Lands and Natural Resources. So if you don't do that, you have breached the Minerals and Mining Act 2006, Act 703. Also, let me put on record that that is different from contracting a company to work for you, because the Minerals Commission is leading a crusade of saying that, look, the mining companies should hand over mining to local contractors, because we have mined in this country for a longer time and we have the expertise. That is the local content regulation that allows the contractors to work as support services. So that is why we had EMP mining for Goldfish at Takwa in Daman, and now the Daman lease has expired. The same thing, Rabotech is mining for Asanko. That is different. So that in that case, that one, it is a contract that has been awarded to a local contractor who has the Minerals Commission license to operate as support service provider. That is different. So let's put that on record. That is different from assigning a mineral right to a different company to work. For that, if you are assigning a mineral right, then it has to go through the minister for his approval before you can assign that. Then we also realized that they were breaching some environmental issues, apart from apportioning some of the areas to some foreign nationals to work, which was not in conformity with law. There were some environmental breaches too. So the Chief Inspector of Mines, who head the Inspectorate Division, conducted this investigation, then made a recommendation to the minister. Then the minister, upon going through it, thought that it had some merit, so the license was revoked. Let me also put on record that as part of the conditions for the grant of mineral rights, you are supposed to pay a mineral rights fee. So that is paid annually, annual mineral rights. So if you don't pay that annual mineral rights fee, it is a ground for us to revoke the license. But before we do that, the law requires us to write to you, to serve you a notice to remedy the breach. If it is a mining lease, we give you at least 90 to 120 days to remedy the breach. Of which, if you refuse to do so, we have the right to write to you to revoke the license, because it is a condition attached to the mineral right that is granted you. So all these were done. Then Adamus, after they were served, wrote to the minister that they think they were not given a fair hearing. They were not given the opportunity to explain themselves and for the commission to have gone on with their recommendation to the minister, and the minister approving same. So the minister said, look, it is only fair and proper that we give them the opportunity so that they can also tell us their side of the story and we can go through it again. So he set up a review committee so that they could review their petition, and also vis-a-vis the decision that had already been given based on the recommendation from the Minerals Commission. After the committee finished their work, the matter even became worse, because then they found out that it is not only annual mineral rights fee that they are owing. They are not paying taxes. They are not paying the royalties. And there were some discrepancies in the production report that they've been given in terms of the production volumes. So based on that, they made a recommendation to the minister that he should uphold the revocation that was done in April 2026. So that is it.
So initially, your issues were the fact that they did not seek the consent of the minister before assigning mineral rights to another person, and secondly, they were not paying the annual mineral rights fee.
And environmental breaches.
And environmental breaches. So those three issues.
Yes.
Okay.
And they were given the opportunity to remedy those breaches.
Okay.
Yeah, but one way or the other, those breaches were not remedied. I listened to my senior brother, Solomon Owusu. I think Solomon's conversation dwells much on the feud between Paul List and Angela List. But if you read carefully all the releases that have come from both the ministry and the Minerals Commission, nothing of such has come up, or it's not part of the decision.
I see. Very interesting. On this matter of, because I realized that you were trying to draw explain the difference between contracting someone to mine for you and then issuing a mineral right. How do you establish both?
It's that simple. So I apart from being a regulator now, have worked all my life in the mine when I was at Shirano Gold Mines. At the time we were mining at Shirano Gold Mines, it was owner mining. So Shirano, as a company, Kinross, the Canadian company, was the one that was mining. That is the pit, developing the pit and getting the ore to the ROM part for crushing and milling and all of you to get the gold. That was the thing. Then it came to the point where the government required that we cannot always give our mineral right to foreigners. They come in, they mine, and they take everything. We need to also empower the local contractors so that they should be able, because we have mined for some time now. So that one, it is a contract between the mineral right holder and the local contractor to execute specific assignments. So that one, the local contractor will not have their own plant. They will not have their own process plant. They are only executing based on an agreement that you are going to mine for us and we are going to process our ore. When you are giving an assignment to a company, you are basically saying that the right that has been granted you, the right that has been accrued you, you are now giving the residue of that right to the company. So the company now becomes the owner or part owner, depending on the agreement. Then It is different from just being a mere contract to execute an assignment that has been given them, or execute a job that has been given, a tax that has, because I'm using assignment, if I don't explain it well, it may confuse listeners. So to execute a tax that has been given you in the mine, it is different from assigning your mineral rights to a company. When you assign by law, even like if you have a land and you want to assign your rights in that land to another person, what you are saying is that maybe you were given the land for 99 years and you have held it for about 50 years. The remaining 40 years, all your rights, the conditions, stipulations attached to that land, you are now converting it. You are giving it to another, a third party, who now takes over all those conditions and stipulations and what have you. So in so doing, you will need the permission of the lessor. That is when it is land. Now, in mineral rights, you will need the permission of the grantor, which is the minister responsible for mines.
I see. Very interesting. In both cases, are they supposed to inform you? For example, if I'm giving a contract out to a company to do a specific job on the mine for me, are they supposed to inform the Minerals Commission?
Yes. You know why? If you are giving a contract to a company to provide support services, the company needs to have a mineral support service license from the Minerals Commission. And
Okay.
it is Minerals Commission that has the repository. So you need to inform us to the Chief Inspector of Mines for him to know, certify that, yes, this company can. That one is not difficult.
I see. So in this case, you found that they had given, what they had done was an assignment of mineral rights. You said there were even foreigners involved?
Yes, according to the Chief Inspector of Mines report.
Now, the interesting part is where you say when they even asked for a hearing and they were given a hearing, it turned out that it was even worse, because Solomon also was also talking about his earlier interest was the fact that they were not paying taxes. It seems you are saying the committee confirmed that they were not paying their taxes.
Yes, so the committee, after giving them the opportunity to speak to them, also went to the mine, did some investigations, and they have come up with a finding that they owe an annual mineral right of in excess of $2 million. They owe some taxes, they owe some royalties and other things that they needed to pay to the Ghanaian people. So it is not as if the decision was arbitrarily or we targeted Adamus as a company.
So what this means is that they've lost those concessions. Do they have any other concessions on record that they are still running?
Adamus, I think, have about 6 concessions, of which 3 of them have been revoked. I would have to cross-check, but I know that they have other concessions. Other than the Salman and Crawford and Kangu, they have Teleku, Bokazo, and other areas. Yeah.
Is this all? Is that the end of it? You revoke their right to those concessions. That is it.
So for now, the minister has directed the Minerals Commission, because in April, when the decision was made and the petition, an interim management committee was formed, which included people from Adamus and the ministry, industry, and all of you to oversee the running of the mine. Now, that has been vested in Minerals Commission for now. The next decision will come from the minister as to whether or not the mine will depend on how they remedy those breaches that has been occasioned over the years. And the minister has written to them, and the Minerals Commission too has written to them. Then it could also be the case that based on the law, if you look at the agreement that is given you, when it is terminated, there are some things that must be done. If so is done, then the commission can go ahead and advertise for a bid. Then the mineral rights can be granted to a different person. A different person, in this case, a different company.
I see. Interesting. I am asking because if you are, I know you are in very active politics. You just said something that looks like exactly what happened in the Wontumi case. Can there be prosecutions in the follow-up to this? I know perhaps that's not your area, but are the breaches basically the same?
I want to defer speaking on that matter.
Well, I see. Thank you. Thank you very much for the clarity.
You're welcome, bro.
Yeah.